Thank you. Madam Clerk, will you call the next case, please?
Xingkui versus State of Tennessee.
Thank you. For the appellant,
Jason Hallman, Your Honor, for the appellant. Good afternoon, members of the court. My name is Jason Holloman. I'm here on behalf of the appellant. And this is a contract case. It was heard by the Claims Commission, and it was disposed of on motion for directed verdict at that time. And we're here today because my client believes that was an inappropriate decision.
sir, have you reserved your time?
I'm sorry, thank you, Your Honor. I'd like to reserve 5 minutes for rebuttal.
Okay.
Thank you. Below, the court did not find that there was a contract or a breach of contract. And I would respectfully submit that the record demonstrates both that there is a contract through the policies that are adopted and incorporated in that original contract, that the issue at stake here, which is overloading or essentially overtime by this professor, is addressed through those policies that are incorporated in the original contract, and that the facts that were demonstrated below and that are contained in the record show that there was a breach of that contract.
You have to provide the written contract. I mean, this is a claim right under 98307L, right? Do you have to provide the written contract as part of your proof?
Well, I would submit that the contract was provided. It is somewhat inartful how it has made its way into the record, but as I said in the reply brief, the original employment contract, which dates from 2004, was filed with the court as part of the motions for summary judgment below. I believe it's the record 752 and 753. It was actually a document filed by defendant in the cross motions for summary judgment that were filed.
Just the contract, though, for 2004 to 2005, I mean, your yearly academic contract comes along, you sign it, and that this is really just the 04-05 contract, which does and has language that's helpful in terms of incorporation and policies. I see what you're saying there, but but we don't have, 04 and 05 aren't the years that are at issue here, right? And we're talking about a much later time period, so we don't have the 2016, 2017, 2018 version of this, do we?
I would prefer that that was in the record below.
Do you have to have it?
I don't think that you do have to have it, because the terms of that contract have not changed in terms of, I mean, this is a form agreement that one of the things I was going to point to and I referenced in the reply is the Setayesh versus State case, which actually refers to that specific language. And that is a standard contract that would have remained in effect, at least that essential term of that contract, which says that these active ongoing policies of the university are also considered. And what was specifically put into the record below at the trial were those policies that were at issue. So I would argue first that it is not a disputed fact, and this court can certainly take note of undisputed facts that are demonstrated in the record. And I don't think at any point they would say he was not an employee of TSU. And the operative and at issue provisions here are what are in those stipulated exhibits 1 through 4. Stipulated Exhibit 4 is what says what are the appropriate workloads, and that is the is it 15, is it 18-hour issue. That written policy is plainly in the record as Stipulated Exhibit 4. And then Stipulated Exhibits 1 through 3 are various iterations of the academic operating manual that say, if you are overloaded, then how do we pay you? And that was stipulated and included in the record. So clearly in the record...
Yeah. How do we get over the finding of the court that there's been specific, no reference to a specific page, paragraph, or line that was breached?
So and I disagree that there is testimony by the professor, the appellant, as to what happened to him semester after semester, and he refers back to those stipulated exhibits, which are the policy that it must be 18 hours. So I think that is just contradicted by the record before this court, that those are stipulated as exhibits. Now, the testimony doesn't take him through those line by line, but certainly this court can review things that are within that record, and he summarizes in his testimony what the circumstance is. I don't think there's any question here what the circumstance was, which is that he was repeatedly asked to teach these two classes simultaneously. And what I would really highlight to this court is that what is contained in the written policies of the university is that you have a 15-hour workload, and if you exceed that, you are overloaded, and then there is text in the policies for how we pay you if you're overloaded. And the response from the university is, well, but we're stacking those classes. So it's really one class because we're having you teach them simultaneously. And they admit both in the record at its response to statement of material fact number 50 of the appellant's motion for summary judgment. They admit that there is no written policy for that. It is a custom, essentially. And the dean that then testified at the hearing last year reiterated that. This is not a written policy. And so, what I would submit to this court is that, while they have complained about the lack of a contract, there is a written contract for employment that expressly incorporates these written policies. These written policies both provide that there is a 15-hour cap per semester, and they provide if you exceed that, then you are paid more. There is no written policy for this stacking term. It's just simply a term that's been shared by the dean and admitted not to be in written form. So I would argue that the written policy obviously trumps any loose course of dealing. What I would also point out in the written policies, there is a prohibition on continuing low enrollment classes. It doesn't say you can merge those together and teach them at the same time like one class. It says that you shouldn't have them. So I think that TSU here is faced with a conundrum that either they have violated their policies and essentially then the workload responsibilities of my client by not canceling an under-enrolled class, or by forcing him to teach two at the same time without pay. Either way they go, they are in breach of contract. So contract has been demonstrated through one or both of those ways they have breached the contract. And then I referenced in the brief, I don't think there's a lot of dispute about damages. Obviously the damages would be the extra hours that are worked over this period of time that are within the statute of limitations for that extra class per the policy as it's laid out. So.
The policy talks about 15 hours or equivalents.
Yes,
Is
sir.
there anything in the policy that tells us the meaning of equivalence?
Well, as I understand, mostly what the equivalency language refers to are ways in which professors can earn those hours through things outside the classroom, like research.
But that only came from testimony at the hearing, not from any policy that we can look for and say, this is what we attribute for this sort of service to the school.
I believe that the policy does refer to equivalency being research time. Okay. Yes, sir. What I know it doesn't include is the stacking concept.
The 3 credit hours that professors are allotted then for research
that's in the policy.
Yeah.
Yes, sir.
Okay.
So, and with that, I'll reserve the balance of my time. Thank you.
Thank you.
May it please the court, I'm almost afraid to say this in light of the last case, but I'm from the Attorney General's office. Sorry. My name is Melissa Broadhag. I've been with the Attorney General's office for many years now, and I do commercial litigation, do contract litigation mostly. And, you know, it's a pretty basic premise of law that in order to prove a breach of contract case, you have to put a contract into evidence. So what's in the record, the technical record, is not evidence. I have this case. I didn't get to do a surreply, so I'm just going to say it to you all now. It's Threadgill versus Board of Professional Responsibility, 299 Southwestern 3rd, 792.
I would suggest if you if you want us to consider something that's not in the record, a case that you send the citation along with the case to the clerk's office for distribution to us.
Oh, okay. Well, I'll just go ahead and, if you don't mind, read this one sentence. The law is clear that statements of fact made in or attached to pleadings, briefs, and oral arguments are not evidence and may not be considered by the appellate court, but I'll certainly see about getting that to you.
With no argument, though.
Yes, sir. Understood. Understood.
General, was it necessary? We've got the 2004, 2005 that's attached to some, not, was it necessary to include the contract from the years, 2016, 2017? Did this case, in order for the plaintiff to make his case, did he have to have that written contract from those years? The subsequent version of the same thing?
Well, so what happens with these universities is they'll do the initial contract and then they won't do another one. And so there is a case, we've had a case, and I think I cited it in the motion for summary judgment, where the appellate court said if it's not a new contract and they keep working, then it's automatically renewed.
Okay.
But nevertheless, some form of a contract must be presented in evidence to make out a prima facie case for breach of contract, to know what the contract is. In this particular case, the complaint tries to make the contract out of the policies, and he just completely ignored the fact that there was a contract in this case and went right to these policies and guidelines to create some sort of obligation that these policies and guidelines don't permit. I just don't think we can look at the fact that the contract in this case adopts those policies, because you don't know what the contract says, because it's just not in the evidence. And I realize I'm kind of going around and around the back door, but if you follow the logic here, he can't just pull his contract out of the air and say, oh, it's actually in the technical record buried somewhere. I put that contract into evidence to be straightforward with the Claims Commission that there was a contract and that the claimant shouldn't rely on the policies. And then he completely ignores it and doesn't put it before the Claims Commission. Also, like I said, the plaintiff wants to contract to concentrate on excerpts of policies and guidelines that he offered as exhibits to create a contract between the parties. But those exhibits and guidelines do not evidence a mutual assent and intention to be bound. The policies, and as a matter of fact, the Claims Commission has found that the policies and guidelines are not sufficiently definite to understand the respective obligations of the parties. And if you look at the guidelines, and this is going to kind of weave into our next argument, on exhibit number 4, the guidelines say the following guidelines are designed to permit the department chair the highest practicable degree of flexibility in making faculty workload assignments. And that's going to kind of lead into our next discussion here. And also in exhibits 5 and 6, Professor Guo himself agreed to these workload assignments that calculate out to 15 with no overload being requested. So he's signed off on this. He understands it at this time, and he signed off on these. So that if there's any obligation created between the parties, it's in 5 and 6, where he's agreeing that these simultaneous classes are not additional workload.
Are we dealing with just the stacking of these minimum classes where he would actually teach 2 classes simultaneously, and they all together do not equal over 15 hours? Or are we dealing with a situation where he may teach one that's 7 hours and another one, 9 or 10 hours or something like that, which they will be in excess of 15 hours?
Well, we don't have the other workload assignments in the record because the plaintiff didn't put them in the record. But I will tell you that they are similar to 4 and 5, exhibits 4 and 5. We're talking about simultaneous classes. And we're not talking about lecture classes, Your Honors. We're talking about studio art classes of the same discipline, where you are tracking a student's progression through an artistic discipline. So you might, and these are all low enrollment cases, which I'm going to come back to in a minute. So you might have like 2 or 3 people with beginning photography, and you might have 2 or 3 people over here that are in advanced photography, and you're just sort of working with them to go through and see their progression. So it's not like a lecture classes where you have to do 2 different things at once.
Aren't there 2 different syllabi though here? These classes have different syllabi, they have, or syllabuses, and
I don't know that was ever really
is that not in the record?
explored
Okay.
very much. I mean, I think that Professor Guo was trying to kind of bring that point across, but the dean of the liberal arts was confused, I think, in her testimony. She's like, it's just following, and I'm not trying to minimize these art classes. I couldn't do them, but she was trying to explain that these are low enrollment classes, so you can do them at the same time. When you have these low enrollment classes, if you look at the policies that are in the record, TSU can cancel those classes. And if the plaintiff has his way, there's no way that TSU or any public university can keep teaching classes with 2 and 3 students in the classes. I mean, you're basically talking yourself out of a job. They have to have some kind of way to be flexible with these schedules. And how do you do that? Remember, the guidelines say that we have to, be flexible with these. And these are not lecture classes. You're not teaching world history, Charlemagne era, and engineering, chemical engineering at the same time to 100 students. These are artistic classes.
Is there any language in the policies that addresses this stacking approach? I mean, I understand your general point in terms of flexibility, but is there any specific language that addresses this type of stacking approach as an alternative to low enrollment classes, or is the language just that low enrollment classes may be canceled?
Well, I think it's the equivalent, because it's not 15 hours, it's 15 hours or the equivalent. And these academics that are in charge of this arts departments have determined that, if these are, in order to keep these low enrollment classes, we have to determine can some of these be done at the same time. And so they're using the equivalent. That's the key. It doesn't say 15 hours. It says 15 hours or the equivalent. And they are, in their academic and professional judgments, saying that is what that means. We can combine, in order to offer these classes, we can combine. I mean, we're not talking about just Professor Guao. We're talking about, you know, ceramics and painting and music. I mean, if you look at music, if you look in the guidelines, there's a whole section on music and combining some of those lessons and classes and stuff. It's not really spelled out for photography, but it is kind of spelled out for some of the other disciplines. I think music is one of them. I know I saw music, but unfortunately I didn't see anything about graphic design and photography. But to answer your question, I think are the equivalent. And you know, and again, he's not. There's nothing nothing in the evidence that preponderates against a finding that there's no overload here, because these are not additional classes that he's teaching. It's not additional time out of his day. He is teaching them at the same time, and the academics who are at TSU and frankly at other universities have determined that this can be done in order to save these classes, because if not, there's no way you can afford to have a full professor on a full professor paycheck teach classes with 2 and 3 people. I mean, it's not sustainable.
General, couldn't the university, I mean, as part of its policies, couldn't it adopt, though, a provision that says we can engage in this type of stacking approach? That's how we can handle classes that way, and then it becomes part of the contract between.
Well, certainly that would be better. That would certainly be better. But what we're dealing with here is what is the burden of proof of the claimant in a breach of contract case, and they have not presented a contract. They've not presented anything that would be a breach of contract. I mean, the Claims Commission specifically said, as Justice McClarity pointed out a minute ago, I don't see there's been nothing that's been pointed to that's any contract provision, policy provision adopted by contract that's been breached here.
So we never get to the policies because we don't have the underlying contract that adopts the policy.
That is our position, yes. That certainly is our position. Yes.
How long a period of time was this teaching situation tolerated before there was a formal complaint as far as the pay that he was receiving?
I think in the complaint, his first, I can't remember it's in the complaint, whatever his first year was. And then that was the other odd thing about this trial. It was just sort of mind-boggling. I was sitting there, and they only brought in 2 workload exhibits for 4 and 5. So you really can't consider that there was an overload at all in any of these other semesters, because he only gave you 4 and 5. And that results in, I think, $8,400. If you were to find in his favor, it would only be $8,400, because it's $700 times the 6 hours of alleged overload. And again, we certainly don't concede that. There was just an utter lack of any attempt there's no discovery in this case by the claimant. He came to trial and just hardly asked his client any questions. There's hardly, we only got 4 and 5, exhibits 4 and 5 in these policies, and no contract, and no argument or no highlighting as to what the breach of contract was. It was just a very, very strange case. But I think the Claims Commission is exactly right here, that the claimant has the burden of proof. We do not have the burden of proof. It's 15 hours or the equivalent. And Dr. Morgan Curtis explained what that meant. In order to be able to offer these classes, these studio art classes, which are not lecture classes, we have to be able to combine it so that the professors can evaluate the progress of these students. It's not any additional time. There might be different syllabi, but it's moving through an artistic discipline. It's not a lecture class. And so that's what she said in her testimony. That's what "or the equivalent" means, and they provided no testimony at all to refute that. And indeed, the testimony, not the testimony, but the documentary proof of the plaintiff through Exhibits 4 and 5 show that he agreed at the time. Thank you.
Thank you. Your rebuttal, sir.
Thank you, members of the court. I do want to respond to a couple of things that were raised. One, in terms of the syllabus, the professor's testimony at the trial specifically identified that these were two separate courses with two different syllabi. So I don't think that's an issue, and that was never refuted by the dean in her testimony. Secondly, in terms of, I guess, the speculative nature of the damages, as this court is aware, specific damages don't necessarily have to be demonstrated only to a reasonable degree of certainty. The professor, in his complaint, actually pled a specific dollar figure based on this multi-year period of $31,500. And in his testimony then, he described systemically by having to repeatedly teach these classes in an overloaded manner for, I think, almost 7 years. That's how he arrived at the $31,500. Would it have been ideal for him to have submitted that documentary evidence for each one of those? I would agree. But it's not required for him to prove those damages. And again, back to in terms of the sufficiency of the contract, the complaint, which was not denied in the answer, says that he's an employee. He is employed. The record, which the court can take note of things that are reasonably ascertainable and not disputed. Obviously, these aren't disputed. They were submitted by the defendant, as she just told you in oral argument. That original employment document was included in the technical record. Again, would it have been better if it was submitted as an exhibit at trial? But it was submitted as an exhibit and authenticated by the professor in his deposition, and then filed and given notice to the court that it existed. And the plain language of that contract is exactly the same as what this court dealt with in the Setayesh case, from 2021, which says that the policies of this university are to be incorporated in this employment agreement. And so what I would come back to is what Your Honor just stated, which is if they wanted to set up a policy, this professor would probably be bound by it. If it said, well, you can either teach separate classes at separate times, or if we make you stack them up, then you're going to have to decide if you want to accept your employment or not. But that is not a policy that they've made. It's just something that they're saying.
You're not asserting, though, that what is this, the 2004, July 6, 2004 document was put into evidence, right? And
it was not put into evidence at the hearing.
Okay.
It was filed for consideration in the motion for summary judgment, which I believe that court could consider in its ultimate.
To use this document as a springboard to get into the policy.
Into the policies, which are specifically made exhibits.
The court would have to, the commission would have had to have taken notice of this document. Was there testimony that essentially this was unchanged, there were no subsequent contracts addressing whether or not over the years the policies kept getting integrated into this employment agreement?
Here's how I would answer that. There is a lot of, well, first of all, there's unrefuted testimony that he was employed as a professor at TSU. So we know that he has an employment agreement. This court has specifically found in the Setayesh case, based on the exact verbatim boilerplate language of a state university, that these types of policies can be incorporated. Separate in the body of law of Tennessee, we have found that these types of policies can be considered in determining the scope of and the rights of employment, not only at public universities, but in other contexts. So I think even if that contract wasn't put into place, it is unrefuted that he was an employee. And it is ideal that that contract expressly incorporates these policies that were put into evidence. But beyond that, this court can certainly accept the undisputed fact that he was an employee and then rely on the body of case law in Tennessee that says these types of employment policies can be considered as parole evidence in determining the scope of that contract. So I think you can come about it one of two ways. Either you can review the record beyond what was filed into evidence at the hearing and say this was an exhibit at summary judgment. It was certainly that the court was on notice of and it was unrefuted. Or you can look at the body of case law that allows us to consider those types of parole evidence in making these determinations about breach of employment contract. And I would just like to, with my final seconds, reiterate that there is a written policy about whether these classes can be taught or not. Certainly, I guess a decision that could be made is we don't have available classes for you. But his frustration is, and I think there were things that were outside of the record, his frustration is that there are people getting paid for these. And he is not. And his additional frustration, well,
If it's outside the record.
I understand. I heard things outside the record too. So, but I'll leave it at that. But he also is frustrated by the fact that there is no written policy that directs this behavior, while there is a written policy that addresses overloading, and that there is expressed language, as Judge McBride pointed out, that refers to what we mean by equivalent, and that really refers to research. It doesn't refer to this stacking policy. So, thank you.
Thank you. In fact, thank you both for your presentation. Your case has now been submitted to this court for resolution. You should be receiving our opinion and our judgment within a reasonable period of time.